With that, I do not believe the chairman is here. I will recognize the ranking member of the full committee, Mr. Nadler, for his opening statement.
Thank you, Mr. Chairman, and congratulations on assuming the chairmanship of this subcommittee. I served as chairman and ranking member of the subcommittee for 13 years, and it holds a special place in my heart. Unfortunately, today's hearing is not an auspicious start. It is based on a crackpot legal theory that would have the public believe that federal supremacy over immigration and foreign relations is an open question. There is no open legal question regarding the state's subordinate role in immigration, foreign policy, or border security. The Constitution is clear. The federal government is supreme in these matters. And it is well-settled law that the Constitution gives the federal government primary authority over immigration matters. As Justice Kennedy, a Reagan appointee, wrote, quote, "The government of the United States has broad, undoubted power over the subject of immigration," close quote. The Constitution explicitly provides Congress with the power to establish a uniform law of naturalization and task the federal government with conducting foreign commerce and foreign relations, which the Supreme Court has repeatedly noted are interlinked. As the Court has observed, the treatment of foreign nationals within the United States can impact foreign diplomacy and trade, including the treatment of Americans abroad. There is good reason, then, why the framers assigned these responsibilities to the national government. On matters of immigration and foreign policy, the nation must speak with one voice. We cannot have 50 different immigration or foreign policies. Otherwise, there would be chaos at home and danger to Americans abroad. The Supremacy Clause further ensures that the Constitution and duly enacted federal laws are the supreme law of the land, trumping any state laws to the contrary. Despite the Supreme Court's crystal clear reasoning to the contrary, we will hear from the majority's witnesses today that the states retain the sovereign power to exclude foreign nationals. That contention was part of the doctrine of John C. Calhoun of nullification. I thought Andrew Jackson and the Civil War settled this definitively and put this notion to rest. Nonetheless, on this basis, the majority and its extreme MAGA Republican allies make the preposterous argument that the states can ignore the federal government and the Supreme Court because the Constitution permits states to defend themselves from imminent invasion when the federal government has failed to act. There are so many practical and legal problems with this outrageous and absurd theory that I do not know even where to begin. Any logical, or dare I say originalist, interpretation of the framers' use of the word invasion in the Constitution makes it clear that the word invasion refers to an imminent attack by foreign armed forces. Multiple federal courts presented with this question have concluded there is, in the words of the Third Circuit, quote, "no support for a reading of the term invasion to mean anything other than a military invasion," close quote. It clearly does not mean the so-called invasion that MAGA Republicans scream about day and night in their extreme right-wing media echo chamber. That invasion rhetoric is often a dog whistle for the Great Replacement theory, a racist and anti-Semitic trope that suggests that a liberal cabal is directing non-white populations to, quote, invade Western countries to replace their, quote, native white populations. After all, who can forget the neo-Nazis and white nationalists chanting, "Jews will not replace us," in Charlottesville? I trust, however, that the American public knows the difference between armed soldiers crossing the border and mothers with their children fleeing violence in the hopes of claiming asylum, as is permitted under federal law. There is, then, no constitutional basis for this MAGA Republican argument that Texas or any other state can ignore federal law at the southern border. If there is no real constitutional controversy, why are we here today? The real purpose of today's hearing is to serve as one more distraction from the MAGA Republican majority's total failure on border policy. In their desperation to avoid blame for their utter inability to govern, MAGA Republicans instead seek to justify unconstitutional state action by blaming the Biden administration and threatening to impeach Secretary Mayorkas. But if they are looking for someone to blame, they should be pointing a finger at themselves. The Constitution vests Congress with the authority to address immigration and border security policy. Yet instead of doing the hard work of negotiating a bipartisan approach to immigration and border security, as is being done in the Senate, the Republican majority is holding hearings like this one. And they are taking their marching orders from former President Trump, who within the past few days has publicly called on House Republicans to sink a border security deal before most members have even seen the text, no matter what it says, all so that he has an issue to run on in November. I must also note that I was deeply disappointed to see the chairman's public call for Texas to ignore the Supreme Court's order allowing the federal government to remove razor wire that Texas placed on the border. Such remarks, from the chair of the Constitution Subcommittee no less, are highly irresponsible, dangerous to our democracy, and sadly typical of the extreme MAGA Republicans this Congress. This hearing is nothing but a shameful exercise in political theater, but I appreciate the witnesses for appearing, and I look forward to their testimony. I yield back.